Good morning. Welcome back to Wicked Wise. So I just want to go over a few things before we get started on some more cases. So Thanksgiving is less than a week away, and I know a lot of people are going to be traveling. So remember, when you leave your area, and God forbid anything were to happen, and you go to their, wherever you're at, their emergency room, and they don't believe that it's an accident, they will call CPS. Okay? Now, they will try to take jurisdiction. If that happens, you are to immediately pull up your UCCJEA, federal and state, because you're visiting, right? Your mother state is wherever you're from. And also remember that Maya just won her case. I don't know if you've seen the movie Take Care of Maya on Netflix, but she won. Okay, so let's start. So if you're going to do pro se, this says pro se must be considered as evidence in this position to a summary judgment of all contentions offered in motions and pleadings, where such contentions are based on personal knowledge and set forth facts that would be admissible in evidence, and where the attested under penalty of perjury that the context of these motions or pleadings are true and correct. So if you're going to represent yourself, make sure that your evidence, everything is correct, because the quickest way to lose credibility in a courtroom is to be caught in a lie. Once you're caught in a lie, it doesn't matter what you say, because your credibility is shot. The next one is a parent's interest in custody of their children is a liberty interest which has received considerable constitutional protection. A parent who is deprived of their custody of his or her child, even through temporarily, suffers thereby grievous loss, and such loss deserves extensive due process protection. A finding of dependency requires proof, which they don't do, requires proof of all parental deficiencies. A parent's right to custody of his or her children is an element of liberty guaranteed by the 5th and the 14th Amendment of the Constitution of the United States of America. A county violates the Constitution when it has unconstitutional customs and policies. Start looking at their policies. A custom or policy can take one of three forms. Okay, so the first one is an express policy that, when enforced, causes constitutional deprivation. Without a court order and they remove your child, that's a deprivation of yours and your children's rights. A widespread practice that, although not authorized in written or law or expressed multiple policies, is so permanent and well settled as to constitute a custom or usage with a force of law. So for me, that says, now this is just my interpretation, right? They say, well, we'll just take you to court, right? Because there is no law. Okay, there has to be exigent circumstances, okay, exigent circumstances or imminent danger. Okay, go back and watch my video on exigent circumstances versus imminent danger. And 3, an allegation that the constitutional injury was caused by a person with final policy-making authority. In order to state a claim under Section 1983, a plaintiff must allege that the defendants deprived him of his rights secured by the Constitution or laws of the United States. and that the defendants acted under color of law. Look up color of law. You can get the form. Just type in color of law form on Google. It'll pull right up. Print them out. I got 400 copies. Children have a constitutional right to live with their parents without government interference. Although it is accurate that the trial court may consider prior parenting history, in a finding of dependency must be based on proof of the parent's present ability to care for the child. Let's see. Accordingly, the department had to prove that Ms. W was presently unable to accurately care for her baby, such that the child, in the circumstances which constitute a danger of substantial damage to his physiological and physical development. When a judge knows that he or she lacks jurisdiction or acts in the face of clearly valid statutes expressly depriving him or her of jurisdiction, judicial immunity is lost. So, with that, you're out of town, accident happened, it's the holidays, CPS comes in, says it wasn't an accident, they don't care what you say, don't talk to them anyway. They don't care what you say, they quote unquote assume custody, which only means they can drive the child from point A to point B. That's all that means, without a court order, right? You go in front of a judge because you're supposed to have a hearing in 72 hours, which normally doesn't happen. They want to coerce you and threaten you and do all that crazy shit to get you to sign a safety plan. Don't sign a safety plan. You go in front of a judge on Monday. Judge says, we have jurisdiction. You're going to do what CPS tells you to do. You're going to piss in a cup. Bullshit. That judge does not have jurisdiction. That's when you use the UCCJEA, federal and your state. Okay? Make sure you have that in your phone. Put it in an email. Look it up. Email it to yourself. Put UCCJEA, federal, UCCJEA, whatever state you're from. And the last one we're going to do, and I will put all these in the description so you can look them all up yourself. Federal tort laws. Judges cannot invoke judicial immunity for acts of violation, for the acts that violate litigants' civil rights. We all know they do it. So my suggestion is, if CPS comes, ask them why they're there. Okay? Don't answer their questions. If you want to answer their questions, you answer their question with a question. Second off, if they quote-unquote assume custody, immediately contact a friend or a relative and file a emergency hearing, okay? Because the Biden administration signed an executive order stating that more children are to be placed with kin and fictive kin versus being placed in child foster care. Now, that law has been in effect forever, but they don't do it. So you immediately contact somebody that has a relationship with this child, get into court as soon as possible, because they have to give that child to whoever. The good thing about the Biden thing, I know some people hate it, some people love it. It doesn't matter. I believe it goes into effect on November 27th, but I'll have to look that up. What it says is all 51 states, all of them, have to come up with some kind of plan, right? There's only 3 things that a fictive kin or a kin provider cannot have, okay? In order to be a kinship foster parent, you cannot have been criminally charged with child abuse or neglect, murder, and sexual abuse. Other than that, they are supposed to get rid of all the barriers. I do agree with those 3, right? Because you don't want your kid if they take your kid in the custody of somebody who has hurt a child before. You definitely don't want them with somebody who's committed murder. And you definitely don't want them with somebody who has been accused or convicted of sexual abuse. So with that, I want to say have a great Thanksgiving, be safe, and I'll see you next time.